application of notice to show cause why first. That the respondent was aware of the orders of this court hearing, and we are talking about the orders here, not in the magistrate's court, first of all, and that has not been disputed at all. On whether or not it has complied with the court orders, that is, the court orders that were issued herein, in its replying affidavit, the respondent heavily relies on the civil court case proceeding to say that it was under the impression that it had complied with the investigations. There is no affirmative deposition that each of the orders above has been complied with. The deposition by the head of corporate that they were under the impression clearly shows that the orders have not been complied with. And going back to the issue of jurisdiction, I'll also find that having relied heavily on the issue of the civil case, the respondent in this matter did not raise the issue of the jurisdiction in its replying affidavit, but rather it has raised it in its submissions. So the respondent also heavily relies on the civil case proceedings to dispose that it complied with orders to supply documents in that case. Then concomitantly, it has complied in this case, but without determining the issues again, looking at the preliminary issue of whether cause should be shown or not, that cannot be the case, because the issue of compliance in the civil case versus the present criminal case was fully dealt with by this court in its ruling on 19th of June 2020. Now, the respondent also says that it has fully furnished all the documents in its possession. However, in the present affidavit here, the respondent also says that it furnished all the documents in its possession and always cooperated, but the supply of documents was not the only order that was sought by the investigators. There are various other issues that it is required to do. And in its ruling, this court considered the issue of why the investigations were important in these criminal proceedings as distinct from the supply of documents in the civil case. And I do not see the respondent setting out one by one the reasons of how it has discharged the said court order hearing in order that it satisfies the court that indeed it is in full compliance. So I'll reiterate that at this point, the court is not determining whether the offense of contempt has been committed, and I must therefore be careful not to go into that arena, because the respondent will then have to have an opportunity to appropriately respond to that issue if called upon. However, at this point, I'll agree with learned counsel for the respondent that following the decision in ZJA and TA-2020 KLR, that this case, the issue of the contempt of court has to be determined by the court that made the initial orders, and that was the magistrate's court. So, having been satisfied hearing that the respondent was served with the order in this case and he had knowledge of the same, therefore, I have good reason to find that he will need to show cause why he has not been able to comply with those orders, because it is evident from his replies that he has not been able to comply with those orders, either because he was thinking that he has been able to do so through the civil case, or because he had been advised otherwise. Therefore, I find it desirable, and it's hereby ordered that the respondent's manager, Mombasa branch, shall appear before the magistrate's court to show cause why contempt of court proceedings should not be heard against him, and that is where the contempt of court proceedings are going to be determined. So we will then need to get a mention before the magistrate's court for the same. When do we go to the magistrate's court? Fifteenth of The matter shall be remitted back to the Magistrates Court, mentioned there on 15th of October 2024, when the applicant will then present its application for contempt of court against the respondent. 15th of October before the Magistrates Court number 1, that is the court number 1? The CM's court. So the CM court will do the allocation, I think. The CM court will then do the allocation to the court that is going to conduct the contempt of court proceedings. Those will be the orders of the court.
Most obliged.
Most obliged.
So we have the other cases.
Miscellaneous E-189 of 2024, Gabriel Nyamawi versus the Republic.
My Lord, I'm present. Adika for the applicant. Ngiri was for the state.
Adika, you will pardon me. I had another engagement. I was not able to finish your ruling. Tomorrow I have 2 rulings. I was really considering to complete this matter due to the issues that you had raised. Give me 9th of October, please.
Much obliged, yeah.
9th of October. 9th of October, we will start with your matter early at 8. Oh, no, we'll do at 9. I have another matter at 11, a 5-judge bench, but we'll do it at 9. 9th of October.
Much obliged, John. Thank you.
Thank you. 9th, kuna case lab. Okay. Okay, I think that's what we had for this afternoon. The court is adjourned.